Folks, Michael Ayala here with Legal View. I want to thank you so much for joining me here on the show. Before I get into this, let me remind you, please like, subscribe, so I continue to bring you this stuff. I truly love doing it. But again, it takes a lot of time and effort, and you're liking and subscribing. And if you think there's anyone you know who might be interested, pass it on to them. That all helps me very, very much. All right, I wanted to talk to you today, give you sort of the morning review of what we saw in the hearings for Carmelo Anthony and his attempts to get a new trial in the case. The first witness called by the defense today was Toby Shook. He was one of the defense attorneys. And I had done a video maybe a couple of weeks ago really wondering about Toby Shook. Where was Toby Shook? He didn't file an affidavit along with the motion for a new trial. His co-counsel, Mike Howard, did. And I was wondering if Toby Shook was in the background. He had nothing to say about this at all. Didn't really see much from him in the news or newspapers or interviews that he had done. So I was wondering where he stood on all this, because he is good friends with prosecutor Bill Werschke. They worked together since 1994. We find out today in the testimony. I mean, people knew that. They were in a firm together. They tried cases together, knew each other very well. At one point during questioning on cross-examination, Bill said, "I trust you very much," and Toby said, "I trust you very much." But I will say this, Toby, he stood up. He stood up. He did the right thing. He came and he testified about this deal and the misconceptions surrounding the deal, and how he didn't think prosecutor Bill Werschke had the right interpretation based on everything he knows about Bill Werschke. So anyway, let me take you through some of this. So Toby Shook takes the stand initially, and he is in a position where he needs to testify about this gentleman's agreement. And it's interesting because, as I mentioned, Bill Werschke went to Toby Shook initially to do this deal. And when he heard the deal, of course, he took it back to Mike Howard, and the implication was that this would help both sides. But this was really about keeping Carmelo Anthony's issues from in front of the jury. And specifically, it's something I mentioned yesterday that came out. Prosecutor's theory was that he was going to school that day and he was all hyped up and worked up and angry. And the reason the knife was in the bag was because he had had a fight with his girlfriend. They had broken up and he had been threatening her, stalking her. She had gone to school that day to complain about the fact that he had been stalking her. He had taken a picture of the knife that he actually ended up using in the stabbing of Austin Metcalf, sent it to her and said, "I'm low-key on the verge." And I said yesterday that was a very nasty threat. It's not a game. And I've said many times about 17-year-old boys and dealing with their emotions and things that are happening to them. And life is coming at them very fast, but it's hard to give a pass when you do something like that, because that young lady was afraid enough to go to the authorities. Now, it turned out, as I mentioned yesterday, that was not the case. They had not broken up. She did go to the teacher. She was worried about that. They had not broken up. She didn't think Karmelo was in that type of mindset, because later texts show that they were kind of working things out, and Karmelo was not sort of in that mindset. He was being a little dramatic. But anyway, when they went to the defense to propose this deal, they felt it was a good deal for both sides, because the defense knew they had what they had on. And again, I went through that sort of arms length things that had gone on with Austin and Hunter Metcalf and the problems there. So Shook assumed that this gentleman agreement was something that was a good thing for both sides. And he felt when Carmelo Anthony testified, it meant that prosecutors wouldn't bring that up in cross-examination. He said that from the defense's point of view, testifying in a self-defense case was completely necessary. So, these are assumptions. And again, I've said before, I don't want to judge the defense based on the decision to do this with all that they had on the victim, because number one, there was no guarantee that the information they had on Austin Metcalf would come in. During testimony today, he was asked about that whole thing, and he said, look, all it meant was that we would have to have a series of hearings as to whether all that information could come in. And again, he also knew, and it came out on testimony today, he knew that Bill Werschke was someone who enjoyed doing cross-examination, was good at cross-examination. And Bill Werschke, when he was asking him, he said, you know how much I love to cross-examine murder defendants. And Toby Shook said, yeah, I know what you like. So again, these attorneys know information about the judge, the likelihood of things happening based on their experience in the jurisdiction, experience with the other attorneys, that we can't substitute our judgment for. So I will not judge them for deciding that this was the right deal. Because if you think about it in terms of the way the defense thought about it, was that Carmelo Anthony would not be cross-examined on all the stuff going on during his day. It was a good deal. Because again, the thing that we had questions about, and I'm sure the jury had questions about and never got answered until this hearing, was why Carmelo Anthony had the knife. And the prosecutors were going to argue he had it because he had this issue with his girlfriend. He even texted her this picture, and that's why he was bringing it. You could even say maybe he was thinking about hurting her. That's extremely damning. Because now you have an actual reason why he brought it. And you could even have an actual reason why he might have been in a very weird emotional space. Maybe even looking to lash out at other people for whatever problems, whatever emotional issues he was having because of his girlfriend. So I think it would give prosecution a much more concrete, because I said from the beginning of the trial, from opening statements, they made that statement that he left the house that day with his knife in his bag to go look for somebody to hurt. And I was like, where are they getting this information from? This goes into another part of the motion for a new trial with the provocation defense. I won't go into that here, but the defense claiming that there wasn't any support for the provocation defense because there wasn't any evidence as to why he would have went to the tent to hurt somebody. The prosecution had this larger story to tell, and by making this deal, they didn't get to tell it. So I can see where the defense thought there was this benefit to both sides. So I'm not going to dispute that making the deal was a good deal if you take into account that Carmelo Anthony could testify. So now on cross-examination, Bill Werschke asks him, do you agree that there was a miscommunication on both sides? Shook said he agrees that there was a disagreement. And Shook says he recalls asking Werschke, how does Chess Club open the door? That goes to, in opening statements, Mike Howard mentioned that Carmelo Anthony was part of Chess Club. Bill Werschke goes to Mike Howard, one of the breaks, and says, you just opened the door to all this bad evidence. Because, quickly, I'll explain how that works. If you make an agreement not to bring in certain evidence, or if certain evidence is said by the judge is inadmissible for various reasons, but don't open the door. If you open the door by something you say that somebody testifies to or that you elicit testimony for, then suddenly that evidence becomes available. In this instance, if both sides agree that none of that evidence regarding their backgrounds can come in, and suddenly you start talking about something positive in Carmelo Anthony's background, the prosecution could certainly have an argument that you open the door to some bad stuff. Because if we're going to make an agreement not to bring in bad stuff, then clearly you understand you can't be talking about all the good stuff. Now, there could be a difference between character evidence and being in Chess Club. Toby Shook was asked this question, and he's like, look, I didn't think that opened the door. Mike Howard certainly said in his affidavit he didn't feel that opened the door. That wasn't character evidence to the point where he felt it opened the door. And ultimately, if they wanted to do that, they could have gone to the judge and had a discussion about it. And I believe they did. There was some reporting that there was that discussion, and the judge said he didn't think it opened the door. But again, it was on the table, and it certainly would have been a question that would have had problems. At one point over this issue, Worski was questioning Toby Shook, and they went at each other. They raised their voices at each other. There were some objections by the defense, and eventually everything calmed down. And when it was all over, during the original trial, after opening statements, and Shook brought this up, and Worski brought it up, Shook said he thought the agreement was still intact and that things would go along as possible. Now, regarding Judge Roach's involvement in all this, again, the judge was part of some of these discussions. And Judge Roach, obviously in the middle of all this, Mike Howard was like, blah, blah, blah. And Judge Roach said he didn't feel he could issue a judgment on the parameters of an agreement that was never in the record. That's the problem of not putting it on the record. And I stand by my feelings that the prosecution didn't want this on the record because they wanted that leeway without any oversight. And what I do put on the defense is not insisting that a deal as important as this not be on the record. Mike Howard, in his affidavit with the motion for a new trial, said that he asked, should we put this on the record? And Worski said, nah, let's not do that. Just file a motion. I've not seen the motion practice, so I don't know what that motion looked like, if it was ever filed. But if he said file a motion and the defense did that, in that motion, I guess they would have outlined the parameters of whatever deal they had. But they ended up where they ended up, and it was a big argument in the courtroom as that went. During the direct examination of Toby Shook, Russell Wilson, one of the appellate attorneys for Carmelo Anthony, asked him, how frequent are these gentlemen agreements used? Toby Shook said they're infrequent. Some attorneys will tell you that they're frequent. My experience is they're frequent, but for small things, little things, not for things like we're going to keep out the backgrounds of people from a trial. And Bill Worski has, even in his questioning today, kept insinuating that this was about helping Carmelo Anthony. And I struggle with that. I struggle with that because when I heard and saw all of the information that was out there regarding the brothers, I think it really put the prosecution's case in jeopardy. Now, again, no one knew how much of that would be allowed in, so there was a gamble. But at the end of the day, boy, that was some tough stuff. And even with the stuff that they had on Carmelo Anthony, I'm not sure it would have made that much of a difference. Now, again, continuing on with Toby Shook, he says he and Bill Worski had known each other for more than 30 years. Again, they were former law partners. And Worski was very, Toby Shook said that Worski was always very complimentary to him, saying that he was a very good attorney. And it was funny because Worski is a very tall gentleman. And he would say, one of his lines was that Shook was the best lawyer in Texas under 6 feet. And everyone in the courtroom laughed, and it was interesting. Wilson asked Shook about the process that the defense used to gather evidence and how that whole agreement came about. And he said, basically, there was some hesitation on the part of some of the witnesses. A lot of the witnesses were friends because they were under a tent for the team that Hunter and Austin belonged to, a lot of the people they wanted to talk to were friends of them, and they were hiding. It was very difficult to get them. But they ended up getting witnesses they thought would be very helpful to talk about some of the things in their background. He said the defense felt that their side would benefit and that Anthony would be able to testify free of questions about any past behavior. He did say that there was an understanding if either side had kicked the door open or broken the agreement, as I talked about earlier, the other side would be alerted right away so that it doesn't happen again. So not that the first mistake, because these things happen, would have initiated the deal. He said that he was pretty sure from his experiences with Bilworski that he knows defendants need to testify in self-defense cases. And this is where my problems with the thought process of Bilworski comes in. Unless he's using that quote unquote chess quote in the opening statement to say the deal was off, which he never said, according to Toby Shook and Mike Howard, how does he think a deal that they made would not include Carmelo Anthony testifying? As a matter of fact, it was interesting because the defense entered into evidence a 2018 presentation that Bilworski would give to various groups of attorneys and CLE, continuing learning. And in it, it says, there's a slide that says in self-defense cases, defendants always testify or very much need to testify as part of prosecutors preparing for these cases. To show that he's aware that if you're going to make a deal like that with someone and your supposition is that their defendant is not going to testify in a self-defense case, it becomes very difficult to argue that you didn't know that that's what the defense was thinking. You would need to say that openly. You would need to say it openly. That, look, I know in self-defense cases, defendant always testifies, but if we do this deal, that means Karmelo can't testify. Very difficult to make the argument on behalf of Bilworski that he didn't know that Carmelo Anthony would want to testify, especially if the parameters of the deal are that we're going to keep everything out and only keep it to what happened under the tent. Not we're going to keep it to what Austin Metcalf's friends and teammates say, or everybody who was there said happened under the tent. So it becomes very difficult. Now, at the end of Bill Shook's testimony, the defense rested their case, and the state started their case. And Bilworski was the first witness called by them. And he talked a little bit about in the beginning, again, one of the issues in this motion for a new trial has to do with the measures taken regarding cameras in the courtroom. And it was interesting because he talked about the fact that there's a longstanding thing in Collin County that there'll be no cameras. And I talked about this yesterday, that one of the reporters out there talked about talking to some of the attorneys, and they knew that the judges in Collin County had this sort of informal agreement that there will be no cameras in Collin County. In Dallas County, that's fine. They do it all the time. But in Collin County, there would be no cameras. And I made my feelings about that clear yesterday. And Judge Roach was all part of that. But Bilworski did say they looked into it. They did a good faith effort. And they looked into the closed circuit TV, and they felt, based on prior experience, and he goes through a few other cases that were high profile or had threats involved, and talked about all the different safety precautions taken in those cases and how it was important for them to keep the safety of all the people involved. So this safety issue, I think, is pretty well established, that the reasons they made the decisions they did in terms of how many people from the public would be allowed in and the seating arrangements, decision not to have closed circuit cameras, that's all well established. It was about safety for everyone involved. But again, based on the law and based on the way it's argued in the motion, that's not the end of the inquiry. Or it could be, but those reasons need to be put on the record, and in this instance, they were not substantially put on the record. as to why these decisions were made. And not only is that required, but it's also required that you take the least restrictive measures possible when restricting public access, because every defendant has a right to a public trial. That doesn't mean cameras in the courtroom. It just means the public in the trial. And that's where they center in on that there were some 27 to 32 two seats available to the public in the entire court, and no overflow room provided, although the possibilities were there to provide that. When Toby Shook was testifying on direct, one of the other things he said was that he was very much passionate about Carmelo Anthony taking the stand, saying it really was the only effective way for the jury to understand why Carmelo Anthony decided to use deadly force. And he wanted the jury to judge him on his credibility. And what he was going for, and this is something many of us have talked about, was a conviction on the manslaughter as opposed to the murder. Rather than he went there with the intent to kill, and he provoked this young man so that he could kill him. He thought if Carmelo Anthony was able to tell his story, the way he viewed the situation, then he could have gotten a manslaughter. And that's what many of us feel this case is. But without Carmelo's testimony, and only the testimony of the people who are supporting or talking from the prosecution's side, it becomes a very different case. And that's always been the divide. People just see Carmelo Anthony as a killer. And the people who are more concerned about the fair trial aspects of this are not necessarily saying that he didn't commit a crime. Although I think there's certainly room on the table to suggest there was a self-defense argument here. But it's hard to walk away from the fact that he had a knife and the other guys didn't have any weapons, but there were 4 of them. It's pretty clear from the video surrounding him. So does that rise to the level where someone could think they'd be in very serious risk of serious bodily harm? It's possible. But, you would put that in front of a jury and let that jury decide. And so he never got that chance to do it. That really bothered Shook. So again, it just reiterates the fact that there was this misunderstanding between the two of them, and it kind of continues along that line. So in terms of moving the motion for a new trial forward, I'm still at the place where it's difficult for this particular motion for a new trial to survive that particular claim because it wasn't on the record. It was a strategic decision made by the defense. Now, the issue is the reneging, but if you have no evidence of reneging, and nothing I saw today in the testimony would make it clear that there was a reneging. What was clear from today is there was a misunderstanding. And I'm not sure how you get beyond that if there's no record of it. Again, I don't know if there's a motion, but if there was, we would have heard about it at this point. If there was this motion that he was supposed to file that outlined the parameters of the deal, if there was this motion in existence, it would have come out in the hearing. So the only thing you have is that there was this misunderstanding. One side says, this is how I saw it. The other side says, this is how I saw it. And that's it at the end of the day. So I'm not sure that there's enough there to get a new trial. The most important part of this motion for a new trial that I thought had some really sort of legal teeth, I'm not sure how much we're going to hear about that. The defense rested before getting deeply into the issue of the provocation instruction being given to the jury. That's more of a legal question. And that's, again, going to really require this judge to look through the record of the trial. He'd have to read the entire record to see if there was anything there to support giving that instruction to the jury. Because by giving that instruction to the jury, the defense is arguing it precluded them from considering any sort of self-defense. But then I think it suffers from that secondary question, was it harmless error? I'm not sure that even if they had considered a self-defense claim by Carmelo Anthony without his testimony if it would have made much difference. So there's that. So I suspect that this will not survive. This motion for a new trial on all three grounds will be denied. It's just the numbers game. A very small percentage of these are successful. But I do believe that there are some interesting arguments to be made at the appeal level. At the appeals level, again, they only look at the law. They're not interested in relitigating cases. It's really about the legal decisions made in the case. And some of the things that they're not talking about here, they'll talk about there because they've already been preserved. Things like the Batson issue, regarding the black jurors. That's one of those things that'll be in that appeals motion. So we'll be looking out for that. And we'll be looking out, of course, on Monday for the decision by this court. And that does it for now. They'll be back in the afternoon. I'll be back with something later today, probably around 6:30 or so, wrapping up the entire day and what happened in the afternoon and the rest of the state's case before it's handed over to the judge. Right now, I'm Michael Ayala with Legal View. Thank you so much for watching. Truly appreciate it. Have a great afternoon. Legal View, where we view the news through the lens of the law.